last week I did a more general discussion. In fact, I probably talked more about history of prohibition than I should have, and should focus on more current law. And in fact, today is kind of doing just that, because really one of the more critical, interesting, and progressive areas of law right now is on the medical use of cannabis. The recreational use and the status of the law and such is important, to be sure. But the medicinal uses of cannabis here in Canada and in other parts of the world has been very much a leading thrust towards change. And in fact, a very recent decision with the Vancouver Island Compassion Society is really, in a sense, at the forefront of this change in law. And having been to about 43 or 44 days out of that trial, which I think lasted close to 50 days, 48 or 49 full days in court, I feel in some sense knowledgeable enough in this particular case to talk about what has happened, what is happening, and why, for a variety of reasons. And before I get into the trial, I should say that it should be obvious, but I'm not a lawyer. Any advice that I give here today is my opinion. It's not some legal advice that should be taken and done without question or thought. And if there is a real legal problem with a grow-op or someone else that you're trying to support, deal with actual lawyers, and don't take my word necessarily for how things are done. But I'd like to think that I know more than the average person, not only for witnessing this past trial, but I've seen about 4 other trials for growers go through various stages of court. And I've also been through several trials myself, including 2 at the Cannabis Buyers Club personally, and I helped direct another 2 trials there. So in terms of having experience being arrested and having my friends arrested and witnessing and going through court, there's really very few people in the country that have spent more days both in the courtroom or reading case law. So, that being said, I want to talk about the VICS trial, so I should say a few things about the case before I get into how the trial went and what it means. Back in May, I think, 2004, RCMP raided a facility with over 900 plants out in the chosen area. I don't want to get into all the details of how and why the warrant was obtained. In some sense, having a class just on how to avoid getting warrants possibly by looking at things like not having much moisture in your windows and trying not to seal up your windows. That's something that's picked up right away, and just a few other obvious things that can be done to avoid police detection. Could be almost a class in and of itself. But the grow-op raid started by an employee at Home Depot picking up on the purchasing of the person, Matthew Barron, who ended up being charged and eventually convicted here. Shopping at Home Depot is putting you at risk of an employee calling a police officer to say that they think that what you're buying is for a grow-op. So in that sense, you're actually a lot safer going to your home little local grow-op as opposed to a big box store. They work with the authorities. Little grow-ops little grow stores depend upon mom-and-pop growers. So really, it might seem like a heat score, but you're not going to get the police called on you there. Anyway, so that's what led to the whole thing. When Matt was arrested, there was a license that Health Canada had approved for 9 plants. There were 2 other licenses in process, one that was being transferred and another one who was waiting for authorization. But even if all those authorizations had been successful, only 90 plants out of the 930 actually had authorization from the government. And because the police couldn't figure out which plants were legal or not, the entire grow was taken down, the equipment was seized, all of those problems associated with a traditional police raid occurred. So despite there being a license, as many people in Canada have seen, if they're not in full and absolute compliance with Health Canada, you know, if their license expires, there's been at times where the police have come in shortly after the expiration date, and people have been charged and stuff. So generally speaking, people need to be very, very careful to abide by the rules that Health Canada has laid out, giving them permission to do it. So in this case and others, you know, it's just treated like another raid right away. And anyway, so that's the basic circumstances, I think, of the raid. Now, obviously, they argued that the pot being grown was for the VICS. Some of what was being grown for research, either strain-based research, where they're trying to prove certain strains work for different medical problems. And in fact, they were even growing hemp to use as a placebo in those experiments. And they were also growing some of the flim-flon, you know, seeds. And for those who don't know, Prairie Plant Systems grows cannabis and sells it and sells seeds. And that's the legal means by which people can get access to plants through the government. So that's the general circumstances. So the VICS argument consisted of a few different thrusts. One of the thrusts hinted upon is that the Prairie Plant Systems cannabis is of very poor quality. In fact, it's been irradiated. English is not my specialty, arguing is. Yeah, they put it under radiation, and without any tests proving what the effects are, and we still, through this whole trial, nothing was disclosed that Health Canada had done anything other than study it as they have for other food products. And so it's actually, yeah, from my understanding, they ship it from flim-flon to Saskatoon, where it gets put into packages. And I think my understanding is they actually put it in an armored truck. So an armored truck full of pot goes from flim-flon to Saskatoon, where they, I think, package it up into smaller amounts. And then they take it from Saskatoon to Montreal. Or maybe, no, maybe it just goes straight to Montreal, sorry. It goes straight to Montreal. No, it does go to Saskatoon, then to Montreal, where they zap it and do a whole bunch of stuff, in theory, to kill the molds and bugs and whatever. And then they send it back in an armored vehicle to Saskatoon, where there it gets divvied up into the personal amounts that people need. So it was put forward very much by the VICS that the local, you know, organic supply that they were attempting to create for their members was a more safe and consistent, reliable source than the flim-flon cannabis. So that was one part of the VICS argument. Substantial part of the VICS argument was based upon precedents set in years past. Certainly the Hitzig decision of October 2003 has been, next to the Parker decision, huge in the movement. Some might argue a step back, some a step forward. But it certainly helped clarify a few issues that were first brought up in the Parker decision of 2000 But the part